My name is Professor Mark Nolan and I'm the Director of the Centre for Law and Justice at Charles Sturt. Can I acknowledge that those of us in this lecture hall on Bathurst campus meet on Wiradjuri land and pay respect to the traditional owners of this land that I have the pleasure of introducing to you all in a moment for their welcome to country tonight. I also acknowledge the custodians of all the lands that you are zooming in from as our online audiences, and I extend respect to all First Persons and peoples in this room and in our online audience tonight. In the spirit of this Reconciliation Week, I too say, now more than ever. Can I note that the embedding of Indigenous cultural competence elements into our Charles Sturt Bachelor of Laws compulsory subjects, one of the sector leading approaches in Australia and internationally, would not be as rich without the generous work of our Bathurst-based Wiradjuri elders in residence. The elders you will meet tonight are permanent staff members at Charles Sturt, as well as working tirelessly for their communities and their families. With Yinjamara and with much generosity of spirit and time, their input, their now virtual cultural immersions with our students, and their wisdom shapes law students and staff here at Charles Sturt in our shared lifelong commitment to improving Indigenous cultural competence. A very heartfelt thank you and mandangu to these elders who are with us here today, not just for today, but for always. They're some of the most legally savvy and proactive users of the law, and they understand their LORE law extremely well. I will hand over to Wirrabee Auntie Leanna Carr-Smith and to Yanha Dharambu Uncle Jade Klim, and pass on apologies from Dinawan Jirabang Uncle Bill Allen, who is unable to be here with us this evening. These elders will welcome us to these beautiful Wiradjuri lands under the shadow of Walu, where the eagles do soar and where their culture has been practiced for tens of thousands of years.
Thank you for that introduction. Made us a little bit fuzzy, warm and fuzzy. I don't think it was a possum skin cloak that was doing that. But anyways, thank you, Mandangu. Yaria Biambu, Gawambana, Wiradjuri Nurambang. I said good evening all. Welcome to Wiradjuri country. Yana and I are both honoured to be here tonight with our special guests, and also to the people zooming in tonight. We've been really busy today. We just raced down from Walu. We were up there with the Legislative Council members, and first and foremost, we need to acknowledge that this university sits on sacred country. This sits at the foot of our sacred mountain, Walu, and we often talk about it. But when you're on sacred country, there's an expectation that people need to have when you come into Wiradjuri country. We often tell our students that we work with and also participants in our lectures that, there are no rules in this land. But there's an expectation that you'll follow Yinjamara. And Yinjamara has 5 principles. And the 5 principles of Yinjamara is respect, do slowly, be polite, be gentle, and have and do everything with honour. So for tonight's session, and for people zooming in and people sitting here in this space, we hope that you hold those expectations close to you, and also when we interact with each other. But for now, we're pretty honoured to be here, and we welcome you all to Wiradjuri country.
Manangu, thank you, Ani. Niwanyani Yana Dharambu. I'm Nyampa Wangaibuan Bilarakiali. I'm Yori Yora, and I'm Wiradjuri Narangi. And I'm honoured to stand here with Ani today and to welcome our very special guest and wish you all well for the evening. And I encourage you at some point this evening to go out and feel the night sky, feel that beautiful cold Bathurst winter on your cheeks, and just think about who has stood in that position before you. Who was here before? It's the 200-year anniversary of the Declaration of Martial Law in August on the 14th. And the Declaration of Martial Law meant the almost annihilation of our people. Our democracy was not built on a nice conversation. There was a war, a hard-fought war, fought here in the plains of Bathurst 200 years ago. And it's not about fault and it's not about blame, but it's knowing where we come from, knowing our own history. And in August, we encourage you, if you're from outside of Bathurst, to please come back and commemorate this terrible moment in time with us as we remember people who have been slain on all sides of those battles, the innocent bystanders. It wasn't just Wiradjuri people that were killed during that time. There were many, many innocent. We ask you to come back and celebrate our resilience as survivors. We are still here. Always was, always will be, Wiradjuri Ngurumbang. So welcome, enjoy your evening, and Mandangu. Thank you.
Mandangu, thank you to our elders for this welcome. On your seats, you will find in those brightly coloured bags, for those in the lecture theatre with us tonight, a flyer for the Duloin events, DHULUNY, that we've just heard about, will be the commemorations in August this year. If you search for Duloin, DHULUNY conference, you'll see a conference that we've organised on the 15th and the 16th of August, with an opening ceremony on the 14th of August, the bicentenary of the Declaration of Martial Law, a truth-telling event that we invite you to. Just some housekeeping for tonight. For those in the Zoom webinar, your mic is muted, your chat is disabled, and you will not be able to post to that chat, but you can read chat sent from the event organisers, and you can post questions and see answers in the Q&A function that we'll monitor and include in the Q&A session for our last 30 minutes or so of this event. When you do ask a question in the room here tonight, there will be a roving mic, and that's important to use. All doors are fire exits that you see here, and the toilets are on the top floor of this lecture theatre. It's now my pleasure, having extended the apologies of the Vice-Chancellor, who's ill tonight, to introduce the Acting Vice-Chancellor and the Deputy Vice-Chancellor, Professor Graham Brown, to introduce our speaker. But we are honoured here tonight to have the first Vice-Chancellor of this university, Professor Cliff Blake, in attendance as well. So I acknowledge your presence and attendance here today. Professor Brown joined Charles Sturt University in 2022, and prior to this, he was the Pro Vice-Chancellor Academic at the University of Western Australia. His other roles at UWA included Head of School of Social Sciences and Dean of Postgraduate Coursework. He's also held several academic roles at the University of Bath and also as a researcher at the University of Oxford. His research expertise is in the political economy of inequality and diversity, including educational inequality and its policy implications. And for 6 years, Professor Brown served on the editorial board of the University of Oxford's Oxford Development Studies Journal, and prior to this was an associate editor for 4 years of that journal. So thank you for being here tonight and introducing our speakers.
Thank you, Mark, for that kind introduction, and sincere thanks to Auntie Leanne and Uncle Jade for that powerful welcome to country, reminding us, I think, of the expectations, as Auntie Leanne said, on us as visitors to this land in many ways. I'd also like to pass on Professor Renée Leon's sincere apologies for not being here tonight. As I'm sure many of you know, she is a lawyer and was particularly interested in attending this talk, but unfortunately COVID has come in the way of that, but I believe she will be zooming in to listen. In her absence, it is my great pleasure to welcome the Honourable Michael Kirby and his husband, Mr. Johan van Vleuten, to Bathurst and to Charles Sturt University tonight. I would also like to acknowledge and warmly welcome back Vice-Chancellor Emeritus Professor Cliff Blake and Mr. Stanley Compley. Michael Kirby is a very well-known name in this country. He's a national treasure. Michael continues to make a remarkable contribution to society after a distinguished and ongoing legal career as a lawyer, judicial officer, law reformer, arbitration lawyer, protector of international human rights for the United Nations and the World Health Organization, prolific author, speech maker, lecturer nationally and internationally, and advocate for LGBTIQA+ rights and HIV/AIDS research organizations, and as a patron of the Qtopia Sydney Queer Museum. Educated with a Bachelor of Arts, Bachelor of Laws and Bachelor of Economics and a Master of Laws First Class Honours, Mr. Kirby was admitted to the New South Wales Bar in 1967 and was the Deputy President of the Australian Conciliation and Arbitration Commission from 1975 to 1983. From 1975 to 1984, he was also the Chairman of the Australian Law Reform Commission. In 1983, Justice Kirby was appointed to the Federal Court of Australia. He was President of the New South Wales Court of Appeal between 1984 and 1996, and the President of the Court of Appeal of the Solomon Islands in 1995 and 1996. Appointed to the High Court of Australia from 1996 to 2009, Michael's judgment and work on that court are well known and influential for law students, academics, and legal practitioners alike. Some of his powerful dissents, in the words of barristers and academics Ian Frenkleton and Hugh Selby, should be characterised correctly as ahead of their time and appealing to the future. Justice Kirby's work on a number of counts shaped all areas of law and represent among the finest examples of judicial interpretation in Australia and elsewhere. Beyond judicial work, Michael Kirby continues to use his formidable legal skills to national and international benefit, including being appointed as the chair of the UN Human Rights Council's Commission of Inquiry on Human Rights Violations in North Korea, and in maintaining an award-winning international commercial arbitration practice. Michael has fond memories of travels to Bathurst from Sydney over the years and has had connections to many Charles Sturt campuses, staff and students, for which we thank him. Lectures have included the annual lecture in honour of Professor Bob Mayen, former Dean of the Faculty of Education, lecturing in Wagga on theories of judicial reasoning, and visiting Albury and Bathurst to engage with business law students and staff, as well as the staff of the Centre for the Law and Justice, as he is generously doing again this week. It is a great honour to welcome such an eminent Australian to our campus and to the podium tonight. Please welcome the Honourable Michael Kirby.
Thank you very much, Professor Brown, for that warm welcome. I'm very proud to be back here again, and I am looking forward to a wonderful graduation ceremony tomorrow, when I will have the great pleasure and honour of receiving the honorary degree of Doctor of this university, which is a it's a great privilege for me, and also for my partner, Johan, who's here with me tonight. I, like all of us in this room, honour the Wiradjuri and the people of the First Nations, and reflect upon the injustice that has been done to the First Nations people, and remind you that some of the most important steps that have been taken to go beyond formalities and to provide real legal rights to the First Nations people have been done not by our elected parliaments, which are amongst the oldest continuous parliaments in the whole world, but by our courts, and in particular by the High Court of Australia in the great Mabo decision and in the Wick decision. I had not been appointed to the High Court when the Mabo decision was made, but I was there when Wick raised the question of whether the principle of recognising Indigenous rights in land extended to the pastoral leases, which cover a huge amount of the territory of the Australian continent. And the High Court of Australia, in that first few weeks of my service, divided on that question, and it divided 3-3. And I, who had just recently been appointed, had the casting vote. And I cast my vote by holding that the principle in Mabo, propounded by the High Court of Australia, expressed most clearly by Justice Brennan in his reasons, also applied to the pastoral leases. And that was a very important decision for the point of spreading the Mabo principle around to more people and ensuring economic equity, without which many of the other equities will not be achieved. I'm very pleased, especially to note the presence here tonight of Professor Cliff Blake. He was a true founder of this university. He played a leading part in tertiary education. He was the head of a number of colleges of advanced education, and then he led them marching into amalgamation to become the Charles Sturt University. And he was, as you've heard, the inaugural Vice-Chancellor, President of the university, and he is a very great Australian. He preceded me in the receipt of the honorary degree of Doctor of the University. He was an extremely distinguished scholar in agricultural science, and he won the university medal when he got his original degree. And I'm very jealous of that fact, because I did pretty well, but I never got a university medal. And it's a wonderful thing that Professor Blake, from the beginning of his career, has been a true scholar and a leader and a great Australian. And he's here tonight with his partner, Stanley, and I honour him, and I'm very glad that they have come along tonight. I regret that the Vice-Chancellor, Professor Renee Leon, is down with COVID and not able to be here tonight. If she is there at the end of the AVL, as I hope she is, I send her greetings and best wishes from one lawyer to another. We've got to stick together, the lawyers, and I'm very sorry that she's not here, but we will find another time before too long for me to return to CSU and to honour her and to express personally the thanks I have for the honour that I will receive tomorrow. Now, my partner, Johan, has been with me for 55 years. I think that deserves a big round of applause. And very soon after I was appointed originally to the Arbitration Commission, a very important post in Australia, I had to get completely on top of industrial law. I had practiced in part in that area, but I had to make sure that if any lawyer threw a point at me, I would be able to deal with it immediately and knowledgeably. And so with Johan, I went on the weekends between the time of the announcement of my appointment and the time of taking it up, and thereafter, to spend the weekend with Johan and his parents. We had then been together for only a mere fleeting moment for 4 years. And so in the back of the parents' home, I studied all the details of industrial law and the Conciliation and Arbitration Act of the Commonwealth, 1904. And his parents, as it happened, had started living in Wellington, New South Wales. And accordingly, we would drive up at the end of a busy week on a Friday night, and we would drive through Bathurst. And in fact, members of his family lived for a short time in Bathurst. They lived longer time in Dubbo and some in Orange. And the result was that they were really people from this part of Australia, although they, like Johan, had started out in the Netherlands. and in fact had gone through the war, a very hard time in the Netherlands with the German occupation, and Johan decided to come out here, and his mother and father came out as well. They are wonderful people, and they are in my mind tonight as I speak to you. We passed through Bathurst so many times as we did this afternoon, and we never thought, if an angel had alighted on my shoulder and said, you will come back here in May of 2024 and you will be receiving a high honour from the university, I would never have believed it. And therefore, it demonstrates once again the uncertainty of life and the wonder of life and the opportunities that we all have to share in the rationality of the human species and to make a contribution in our own country, in our own region and district, but also internationally in this age of nuclear weapons and climate change and all the other problems of the moment, to make the world a better and a safer place. And that is an obligation of all human beings, but a particular obligation of those who have had the blessing of education in a country like Australia. Every night, Johan and I watch the latest doings of President Trump, former President Trump. And if I say to you that it's a slightly upsetting thing, you'll understand. I mean, I'm not immediately affected by it, but all of us are very much affected by the President of the United States of America. And therefore, sitting there watching on YouTube the latest events of Mr. Trump and of his trial and of Stormy Daniels and all the others who are appearing in those cases, we always watch it for a time, but we then switch the television to the YouTube records of the planets. It's a healthy corrective to the travails of our world and the dangers of our world, to see how amazing it is that the human mind sought to understand the universe and sought to understand the Milky Way and sought to comprehend the galaxy and to look behind our galaxy to the other galaxies and all the wonder of the universe at first, and the massive size and dimension of it. It really puts the problems of the world in perspective. And if you haven't seen this, I do urge on you that you'd look at YouTube with the images of Mars and the images of the other planets. It's wondrous to see them and to see that this has been achieved by human beings and by universities and scholars and scientists to send instruments to these far-off planets and to understand the enormity of space and of the universe and of our duty as human beings to respond more sensibly to the dangers that we face. And Johan and I have come to the conclusion that one of the solutions to the problems of our world would be to take Mr. Putin, to take Mr. Trump, to take Mr. Biden, to take President Xi, and maybe we'd throw in Mr. Albanese and a few others into a locked room so that they are forced to sit there and see the wonder of the universe and how trivial in comparison to that are the problems that they are so preoccupied with. and raised to the danger of all of us and danger of human life and human beauty and human music and human love. That would be a good curative, in my opinion, for the ambitions of a few politicians. Professor Mark Nolan, who must be the best responder to emails that exists in Australia, and who is must be sitting there, acting Vice-Chancellor Brown. He is sitting there day and night, slaving away. And if I ever send an email to him, he's hot on the button, and back comes his response. But he wanted me to come here tonight and talk about the issue of international commercial arbitration. Now, that is, shall we say, a very important subject and a very interesting subject, and it's one that I know a bit about because I've been involved in international commercial arbitration. I'm sure there'd be a few lawyers here who'd be interested to hear about it, but it's not, shall we say, an issue that would be of great abiding interest to a lay person. And lawyers have got to learn to speak to lay people and to speak about their concerns and their issues. And so I plucked out of the air the topic of the retirement age of judges. As I have long past retirement age of judges, but I'm still very busily at work, I thought I should reflect upon that and explain to you what happened in Australia to change our constitution and change our law, and to demonstrate that, contrary to all rumours that it was impossible, Australians sometimes have changed their constitution. And in fact, the very last change in the Australian constitution that was approved as long ago as 1976, the 21st of May 1976 is the last time Australians voted yes by the requisite majority required by Section 128 of the Australian Constitution. And on the 21st of May 1976, they voted yes to the proposition that Section 72 of the Australian Constitution, providing for the appointment of federal judges to federal courts, tribunals, should have the power in the federal parliament to enact a retirement age. To understand why they did that, it's necessary to go back deeply into ancient history. Now, nobody teaches, or almost nobody teaches, legal history now. In most universities, you are not taught about the long history that goes before the present time, and I think that's a very bad thing, and I'm going to launch into a personal campaign to restore legal history, because how can you understand where you are unless you've understood where you came from and how you got there? But the legal history of Australia, the history of the Australian colonies and states and commonwealths are, in a sense, the product of the legal history of England and of Great Britain and of the English-speaking people, because that's where the steps to develop a legal system that we have in use in Australia really originated in England. And the English legal system originated back before 1066, when William the Conqueror came over from France. I'm not going to go slowly through this. I'm going to take you on a rapid tour of legal history back to 1066. And one of the early kings of England, Henry II, was a very imaginative monarch. And he decided that he would establish the law courts in London. There had been courts before, but he decided that he would send the judges of the law courts from Westminster out to the provinces in England. And that was a very important and unusual step to take, because until then, monarchs generally thought people should come to them rather than they're sending their officers to bring justice and law to the whole population of the country, of the realm. And so that's what he did. But the judges of his time, and indeed for centuries after it, were basically members of his royal council. They were, I suppose you would say, relatives, friends, and others who were trusted to speak on behalf of the king, who was the font of justice and law, and to decide disputes, because he reasoned that if you had a system like this, that would be a much safer and more peaceful way to resolve disputes than by warfare and battles and all the other methods that had been used until then. Anyway, that's what he did. But because they were within the personal service of the monarch, they held their office during the lifetime of the monarch. And when a monarch died, all of the commissions of the judges were cancelled. That was the end of the judge's service. And it depended on a lot of chance and luck whether the judge would go on to serve the successor monarch. It wasn't automatic. And the Times led to complaints that this meant that judges were at the will of the monarch instead of being in a permanent position with a guaranteed status that would continue if the monarch died. There were efforts to introduce that system over the centuries, but it really wasn't secured until the Act of Settlement and until the revolution that happened in England in 1688. And when that was settled, the rule was laid down that the monarch death would not terminate the commissions of the judges who that judge had appointed, and that those judges who had been appointed would continue to serve quam Deus bene gesserit. That was the Latin phrase. I'm the last generation, I think, of people who at school learned Latin. Quam Deus bene gesserit, whilst of good behaviour. That was the expression. And therefore, the judges became semi-permanent. They held office during good behaviour. That had a technical meaning, and it meant that they could be removed, but only if they were shown to be incompetent or if they were shown to have been corrupt in some way. And because this was the principle that was adopted by the English monarchs, it was then shared in countries which derived their legal tradition from Great Britain. And one of those countries was us in Australia. And so when the United States Constitution was adopted, it said that the judges of the federal courts would be appointed by the president and would hold office until and unless they were removed for proved incapacity or misconduct. And those limitations were designed to protect the judges so that they weren't dependent on the will of the monarch, or in the American case, on the will of the president, but were giving a status and a permanency to the people who held the office of judge. It was thought that if they're at the whim of the monarch or the president, then that will not be good for the safety of the judge and the courage of the judge to decide cases. It would lead to a great deal of uncertainty as to what happened to the judge if the president of the day took a dislike to them. So that was the provision in the American Constitution. And when the founders of the Australian Commonwealth came to establish our Commonwealth Constitution, they copied substantially in what we call Chapter 3 and what the Americans call Article 3, provisions similar to the United States provision. And it said that judges will be, federal judges will be appointed by the Governor General and will hold office unless removed from office for proved incapacity or misconduct decided by resolution of the two houses of Parliament in the same session. So that's our system, and it's a system that's designed to build in protection for the judge so that they're not subject to the whims of politicians. Any of you who tarry with YouTube and watch Mr. Trump's travails will realise that that sort of provision has a very important purpose, social purpose, of protecting the judges from opinionated politicians who might take a dislike to them and want to get rid of them. And that was the system they had in the United States and also in Australia. Now, in 1901, the very last act that Queen Victoria, as the Queen of Great Britain and Northern Ireland, signed into law was the Commonwealth of Australia Constitution Act. And she signed Victoria RI up the top right-hand corner of the document, and that then became our Constitution. That Constitution had in Section 72 the provision that I've told you, providing that the Governor-General can appoint judges and also providing that Parliament can remove judges. It didn't say anything about the term of the judges. It didn't state and set out, well, the judges can sit for a particular period, 14 years is what they have in South Africa, that when the judges are appointed to the new constitutional court, they hold office, as the German judges do, for a fixed term of years. And in South Africa, it's 14 years, though it can be renewed. However, in Australia, our constitution said nothing about a term. It said nothing about a birthday. It said nothing about when the judge had to go. And that provision lasted until 1975. Some of you will remember that in 1975, on Remembrance Day, the 11th of November 1975, a very exciting thing happened, constitutionally speaking, in Australia, because Governor-General Sir John Kerr dismissed the Whitlam government. And there was then a great deal of unrest. I'm not going to go into that saga, but it led to the defeat of the Whitlam government at the election that followed in December of 1975, and it led to the installation of the Fraser government. And so early in 1976, it became necessary for the new members of the House of Representatives elected in the election at the end of 1975 to be sworn into office. And this is normally done by a sitting of the Senate in Canberra, and to the Senate comes the Chief Justice or a Justice of the High Court of Australia. Now, the Chief Justice at that time was Sir Garfield Barwick, who had himself been criticised for what role he had played in the Whitlam dismissal. But that's not relevant to what I want to talk about. Barwick wasn't there because he was in London sitting in the Privy Council, because our Chief Justice was if he got a commission, he was a Privy Councillor, and that's what Barwick did. He was over in London doing it. So what then happens is that the next most senior justice is called upon to come to Parliament House, and in the presence of the new members of Parliament, to swear in the new members of the Parliament. And the next senior justice of the High Court at that time, in early 1976, was Sir Edward McTiernan. Sir Edward McTiernan was by that stage a very old man. In fact, he would have been very close to, if he hadn't actually reached the age of 90. And so he was a man who had been appointed in 1930. And so he'd been serving as a Justice of the High Court from 1930 to 1976. And shall we say, when he came along to the Federal Senate, he was seen as somebody upon whom the bloom of youth had long since passed. He was a very, very old man. He was a very distinguished man, but he had a very wavering, wobbly voice, which made it very difficult to understand him. And when I appeared in the High Court, which wasn't very often in those days, I found it very difficult to understand him because he had this wobbly old voice. And also, he was very frail, as people of 90 can sometimes be. As I begin to approach the last period of the decade I'm in, and as the age of 90 begins to loom in the distance, I begin to understand the difficulty of Sir Edward McTiernan. It wasn't his fault, but he had life tenure. There was nothing in the Australian Constitution that said that the judges can be retired at an earlier age, and therefore it had been interpreted that that meant that the judges, the justices of the High Court and other federal courts, were there for life. And Sir Edward McTiernan was taking that literally. And he was there nearly age 90, and he was in no way going to give up his seat. And in fact, he lived on for about another 6 years, but he didn't serve on for another 6 years because Sir Garfield Barwick, in an act of judicial petulance, when Sir Edward fell over chasing a cockroach in the Windsor Hotel in Melbourne, when he was sitting in Melbourne, when that happened, he fractured his hip. His operation was only partly successful, and he needed a ramp to get onto the bench. And Sir Garfield Barwick, rather unkindly, you might think, refused to provide a ramp, and Sir Edward McTiernan therefore ultimately had to leave, not entirely of his own volition, but because of the combination of circumstances. But when the members of Parliament came and saw this very, very distinguished and very old man who was there to swear them into office, they were rather shocked. They saw Barwick occasionally, and he was a sprightly 75-year-old, but they didn't see the other justices, and none of them had probably ever seen, certainly not heard, not watched at work, this very old man. And they had to take their oath or affirmation of allegiance and oath or affirmation of office. They did so, and but they went away from there, and they said to each other as they got out of court, "Did you see how old that man was? How old he is? Why is that?" And then people had to explain to them that's because the High Court in 1918 had said, because there's no express provision for the retirement or for Parliament to adopt a retirement provision, it therefore implied that they can stay forever until they're good and ready to go. And that led to a groundswell. Well, if you can have a groundswell in the Federal Senate of Australia, it's a very, very august body, moves generally rather slowly itself, but there was a determination that that must not happen, that he should have been subject to a provision that he had to go, that the members of Parliament were subject to election, and if the people, the electors, thought they were too old, they would get rid of them. And it wasn't good enough to have judges in office without any limitation, and therefore that they should move to get agreement of both sides that there should be a power in the federal parliament to provide by law for the retirement of judges. But to do that, they had to overcome this decision of 1918 that had said, it's not there written out, and therefore you can't make us go, and you've got to keep us until we're ready to go. And that was the decision in the case called Alexander and Co., which was the case that prevented that legislation being enacted. And that was why ultimately in May 1971, there was a constitutional referendum. As I told you, it's the last referendum in Australia that succeeded. None of the other referenda provisions have been adopted since 1977. The constitutional amendment to make Australia a republic failed. It failed in every state. The constitutional provision to make a voice for the Indigenous people, whom we have acknowledged and knifed, that failed, and everything in between had failed. And therefore, they had to put it up to the people, but they put it up to the people, and the people of Australia voted yes. And they did so because the arguments were, we've got to have a younger judiciary, we've got to have a judiciary with vigour, we've got to have a capacity to for Parliament to provide a decent time that, like every other public officer, they will go at a certain time, not of their own choice. Now, Sir Garfield Barwick disagreed with that provision, but people said, well, he would, wouldn't he? But the people of Australia voted by 80% to provide that Parliament, that in the case of the High Court judges, they must go at 70. And in the case of other federal judges, they must go on the day, not being more than 70, that the Parliament provides. And so that was the provision that went to the vote on the 21st of May 1977, and it was adopted by 80 to 20%. And therefore, that is the provision we have. Now, some people think that that was a bad thing and the end of civilization as we know it. And I know my colleague, Justice McHugh, thinks that the respect for the judiciary has fallen away ever since the judges lost the power to order the execution of prisoners who are found guilty of serious crimes. It's not a view that I personally would hold, but he says that once a judge lost the power over life and death, they had lost a lot of the power they had in the imagination of the people. But also, he thought, and a lot of judges thought, indeed, probably a majority of judges thought, that this requirement that judges should have to go at age 70, and in the case of some federal or lower federal courts earlier, was a very bad thing because it meant that judges who were people of great capacity and continuing capacity to contribute to the nation and to the Constitution and to have the years of service that would command respect, that it was a bad step that was taken. And a lot of people have said to me, well, you would agree with that. Look at you now, you're still going strong and you're still turning up at Charles Sturt University and giving a long lecture, and you've still got your marbles. So we've lost the benefit of having you serving on the High Court of Australia. Well, my answer to that is too bad. There are plenty of other people, plenty of other lawyers who have great ability. They should have their opportunity to serve. And in fact, having the provision that has now been inserted in our Constitution ensures that we get generational change in our judiciary. And that is a good thing, in my opinion, because you've got to have people who will reflect the values that are changing. I mean, none of the judges of my generation would have had any experience with mobile phones or emails, and I've had to learn all those things. And I'm still trying to get my brain around artificial intelligence. So a lot of things are happening now, technological things. But if there's a will, there's a way, and you can do other exciting and interesting things, as I have done. So I have never agreed with Justice McHugh about this. I've never agreed with other judges who've said, this is a terrible thing that we've been deprived of your service. I've had plenty of other things to do, and my service is continuing, but I think it's a good thing. I voted for it. I'd still vote for it. I think it was a decision that was long overdue, and you could, if you wish to be unkind, call it the McTiernan Amendment. And if you look at the United States of America today, many of the problems that the Americans are facing are problems that come from the fact that their judges still have life tenure. It's a very bad thing for judges to be around for an indefinite period so that they have the say as to when they go. And I think the experience of the United States is a good illustration of what can go wrong if judges hang on for too long. So that's what I wanted to tell you. It was rather a long version of the story, but unless you know the legal history and how it came about, you won't really appreciate the nuances, and in particular, the nuance of Sir Edward McTiernan coming into the Senate, a very old man who horrified the senators and members of the House of Representatives and led to the last amendment that the people of Australia adopted. It is a question as to why Australians are so reluctant to change their constitution. But the last change that they adopted was the, one might say, unkind change to tell judges that at a certain age, their time is up and they have to go and do other things. And I think that was a good decision of the people of Australia in their wisdom. So that's my talk, and I think I deserve a big round of applause. And then we'll have and please don't complain about the length of the talk. I was told I had to talk for 3/4 of an hour, and that's what I've done. And now we have time for questions. If you have a burning question on international commercial arbitration, you can ask that question now, or any question on what I've said or anything else, or if there are any law students with questions for their essays or exams, they can also slip those in. But thank you very much for having me tonight. Well, Q&A. How are we going to do this? Are you going to?
I'm going to stay where I am. You're going to stay where you are. And anyone in the room who wants to ask a question can raise their hands and there'll be a roving mic taken to them. We've been harvesting questions from the Q&A online as well, so we will blend some of those questions into the Q&A session. Mr. Kirby did say earlier on in a dangerous way that he would be prepared to answer almost any question that he's prepared to answer on any topic, not only this topic or the interesting topic of international commercial arbitration. So it's open slather, really. And we can take some questions from the floor first and then move to the Q&A online. So, Acting Vice-Chancellor, I think you have the prerogative to ask the first question.
Thank you. That was really fascinating and aside from anything, a good argument in favour of the reinstating of legal history in the legal curriculum. As you were talking, though, I was reflecting that the UK, of course, doesn't have a constitution, and indeed recently changed the retirement ages of judges upwards to the far more respectable age of 75, simply by ministerial diktat. It didn't even need a law, let alone a constitutional change. And so I was reflecting on what you were talking about and what's been very much in the background, the failure to vote for Voice last year. And I wondered what your perspectives were on where the right balance lies in terms of how hard you make it to change a constitution. So, you know, one of the Taiwan, I believe, has a constitution where 50% plus one of eligible voters, and they don't have compulsory voting, have to vote to change the constitution, which means they will never change the constitution because they don't have compulsory voting, versus the sort of UK type system where these changes can be made overnight because there isn't even really a written constitution. Where does the right balance lie in constitutions?
Well, the UK is an unusual case in that, as you say, it's not true to say it doesn't have a constitution, but its constitution is in lots of acts of parliament and international treaties that have been adopted and decisions of the ministers and subordinate decisions. So it's a mess, but they do have a constitution. I may be wrong, but I thought the UK introduced changes in judicial tenure by legislation, and it may have been just a ministerial decision, but it would have had to be made under a power that the minister had. But originally, the UK changed the date of retirement to 68, and then it subsequently put it up. And in New South Wales, our parliament, which is not in this respect subject to the federal constitution, our parliament initially provided that judges must retire at 70. That's where the 70 came from New South Wales and other states into the federal constitution. But since then, as I was reminded tonight by a distinguished Australian judge from the Supreme Court, who is here, the time of retirement in the states, in New South Wales and in Victoria, has been upped from 70, which it was when I was serving on the Court of Appeal of New South Wales. It's gone up to 75. And in Canada, it has long been 75. So for those who hanker for very old judges, then you can say we're going to change it to 75. And I can understand that decision. Personally, I wouldn't favour it. I think the judiciary is already, in terms of its values and philosophy, a very conservative group of people. And therefore, on the whole, I think it's better to give them a little bit of a stimulus to go, because there will always be very clever people coming along who should have an opportunity to serve, and particularly to secure changes. For example, changes in the number of women judges. If you've got the same old group staying on for very long times, then you can't make those changes because people are in office. And even in the case of the Australian constitutional provision that I've explained, it was made only prospective. In other words, it didn't get rid of those who already had life tenure. And Sir Garfield Barwick clung on to his office as Chief Justice of Australia until about the age of 78, I think, because he had diabetes and he was losing his capacity to read, and therefore he decided then that the time was up for him to go. But there are plenty of talented people around, and in some professions, we've got to have a shake-up and we've got to change. I tell you one profession, and I go to a lot of conferences, that is very unbalanced, and that's in the information technology profession. All men. The conferences you go to of information technology experts, you know, it's something like 80% males. And I don't know why this is so, because there's nothing on the Y chromosome that means that women can't do computer technology. And I went to my old school in Sydney, Fort Street High School today, and there were 3 people talking to the students about leadership. I was one of them, and you could imagine I was giving the message of stirring things up. And the other was David Anderson, who is the general manager of the ABC. And he had a very important job in Australia, the national broadcaster. And the third was Dr. Shiva Lingam, who was a refugee from Sri Lanka, Tamil refugee who fled the revolution in Sri Lanka. And she is a top neurosurgeon. And she said when she arrived at Royal Prince Alfred Hospital and finished her degree, the number of women neurosurgeons, you could count on the fingers of one hand. And it is changing, but it takes a lot of time for these things to change. And sometimes you've got to give it a bit of a help. That's why I want to propound a practical and really, you might say, political or philosophical reason. We should change the time of service of people who have the power to make decisions affecting all of us and who have the great responsibilities. And I don't say that applies so clearly to a neurosurgeon, though I would think that maybe it does. But it was wonderful to see this neurosurgeon. She would be about age 35 or 36, and she's now one of the top neurosurgeons in Australia and works at Royal Prince Alfred Hospital. So if you've got any brain problems, that's to say, problems that can be fixed up by surgery, then she would be one of those who would have the responsibility. A very clever woman, and no reason why there shouldn't be more women as neurosurgeons. And that's what she told the class of young students in public schools from all over the Sydney district this morning, today. I'm not content to make one speech in a day. I come to make two. Any other questions?
More opportunities now. Plenty of questions in the room. I'm going to take one question online and then come to some questions in the room. As a student starting to study international law as a mandatory subject this session at university, what, if any, different mindsets do you need to do well in international law and understand international law compared to the typical traditional priestly 11 subjects that are not international law?
Well, that's a good question. And in fact, it's a rather controversial question in the context of the decisions of the High Court of Australia. I have always been of the view that in our legal system, we have to keep stability, but also we've got to move with the change. And one of the big changes that we all would know is the change of internationalism, international technology, international institutions, international law. And so the answer I would give is that this view of mine is not yet fully adopted, though it was adopted by the High Court in the Mabo case, because it was in the Mabo case that Justice Brennan said, the provision in our law that we do not recognise the land rights of Indigenous people was made by judges and can be unmade by judges. And the one principle of international human rights law that is universal is that you cannot deprive people of their rights because of their race. And that became the key that unlocked the door, that opened the opportunity in the Mabo case for dealing with the lack of rights of Indigenous people. That passage in Justice Brennan's decision, I would mention for the sake of this student, the questioner, is at 175 Commonwealth Law Reports, page 1 at 42, because that is where Justice Brennan says the one principle that international law speaks clearly and unanimously on is that you cannot deprive people of basic rights by reference to their age. And I normally have with me the Universal Declaration of Human Rights, an international instrument. I always keep it in my pocket because you'd be amazed at what wisdom you can find out of it. The first article of the Universal Declaration, which was given to me at Summerhill OC class in the year 1949, because it was adopted in December 48, the first principle is wonderful. The language in English is wonderful. All persons are born free and equal in dignity and rights. That's the sort of core notion of this. And that was the principle that Justice Brennan introduced in the Mabo decision. And that was done by the help of international law. Okay, next.
Thank you for that, Justice Kirby, your entire speech. I was privileged as a student to first hear you speak at Sydney Town Hall in 2001. Yes, you won't remember, but I do. And, you know, even talking to friends today saying I was coming to hear you speak, they said they remembered, you know, what a wonderful speech you gave and how much it had impacted us as students, and that reputation that you carried and other justices carry throughout, you know, their career as judges, but also after. Which leads me to wonder, you've mentioned the United States and the schmozzle that's going on over there, but I wonder what the politicisation of courts especially the Supreme Court in the United States, which is the most sort of publicised court in the world, what that does for the dignity of the judiciary as a whole, and can we recover from that?
Well, first of all, the dignity of the judges is less important than the wisdom of what they do. The Constitution is a political document. It deals with big political questions about the country and its governance. And you can't get away from the politics of judging constitutional questions. It's just part of the job. What is not permissible is being political in terms of a political party. And in our tradition in Australia and in England and in Canada and in New Zealand and in most of the English-speaking countries, judges have nothing to do with politicians. They don't meet them, they don't telephone them, they don't have friendships with them. In the High Court, when we'd finished a week of work, and it was an arduous week, we would go to Canberra Airport, and by arrangements which were made by the High Court, a special room was set aside for us so that we could be in this room and not be buttonholed by the politicians. And that's very important, and I approved of that, not because I thought I was better or more important than the politician, but the politicians have have their ear close to the people and listening to what people are saying. And the experience is that if you don't separate them, they might, power is corrupting, and they might try to corrupt, not in a money sense, but corrupt the mind and the thinking and the legal reasoning of judges. So I wouldn't be too worried about the politics of decisions. What is a little unsettling in the United States is that they divide down the line, and on the abortion issue, for example, although that does raise very large questions of policy, the question was whether they continued to follow a decision which had been laid down and which gave people certain basic rights for more than 50 years. And that was divided down the line. Those who had been appointed by Republican presidents all voted to terminate the right to abortion as resting in the Constitution. And the three justices who had been appointed by Democrat presidents, they took a different view. So that tends to make it look as though they have had a political, party political differentiation as distinct from political philosophical views. I hope that's reasonably clear.
We have a lot of difficult questions in the chat online, which I may seek some answers from you, Mr. Kirby, over the next day or two, and send some replies back to our audience.
You're going to send me more emails. And
Possibly.
I've got to answer them as quickly as you send them.
Though quickly, one question is, what is your view on the need for a Bill of Rights in the Australian Constitution? That's a simple and short question for you. And then we'll go to some questions in the audience.
Well, it won't come as a surprise that because I go to bed with the Universal Declaration of Human Rights, it's something that I think we should have in our Constitution. In fact, there have been studies of the knowledge by students at school of the fundamental principles of human rights. And those studies have shown that in Massachusetts, in the United States, students have much more knowledge about and much more capacity to think about and talk about basic rights of citizenship. And that's an important aspect that we're missing out on. So I'm in favour of a national constitutional Charter of Rights. Virtually every other country in the whole world has a constitutional charter of rights. So what's so wonderful about Australia? What is so perfect about our governance? Why have we not ever done anything that offends fundamental human rights? That we wouldn't be helped by having some basic principles. But I don't think I'm going to live long enough to see that happen. And therefore, I don't lose too much sleep about it. The real question, which is on the agenda, and there's going to be a big conference in Sydney next week about human rights, is whether we should have a Charter of Rights. That's one that was enacted by federal parliament or state parliaments, and whether that is a sort of step in the right direction, which may be easier to get. Very hard to change the Australian Constitution. We saw that recently with the Voice. Very hard to change it. And that isn't always a bad thing. When Dr. Evatt won the case in the High Court about banning the Communist Party in 1951, the Menzies government had enacted the Communist Party Dissolution Act, and Dr. Evatt challenged that in the High Court, and the High Court struck it down and said it's unconstitutional. You've got plenty of power to deal with communists for what they do, but you can't deal with them for what they think. That belongs to them, and Parliament's power doesn't extend to that. A very good decision. And it saved us in Australia from going down the path of South Africa and other countries. And I therefore support that. But I do think a charter would be a good thing, and I think that's what's going to be debated next week, and you may see some publicity to this, and that may put pressure on the politicians in Parliament to adopt a Charter of Rights.
Justice Kirby, thank you for presenting tonight. It's been an honour for all of us to listen to you. I was reflecting on your argument tonight, and I found it persuasive in many ways, but I can think of at least a couple of reasons why it would be a good idea to have at least some older justices, perhaps only one. One would be to represent the older cohort of Australians and their perspectives. Another reason is that there is wisdom in the generations, that there are some periods of life that, you know, older people have gone through that younger justices would not have, and that really shapes their values, their understanding, their knowledge. What I wondered was whether an alternative strategy might have been to be in the military. You have a certain number of years to be promoted, and if you don't get, say, to brigadier by a certain point, you're out. I wondered whether there was a place for, you know, a judge that could be between 70 and 75 years of age, just that would hold those perspectives and could advise, you know, from that perspective. But you know, you have an opportunity to get to that position, but at 75 you move on. But it's only one person, so there's still the new justices coming along, but there is provision for the representation of from senior justices.
Thank you for the question. I've already said that I won't go into battle about extending it to 75. Because we're all living longer, and therefore, not all, but people on the whole are living longer ages because of improvements in medical care and so on. But judges don't advise, judges decide and order, and therefore they're part of governance, they're part of power. And how would you change this? You can't have different qualifications for judges, I don't think. You can't have, say, well, one of them is going to be over the age and one of them is going to be an Indigenous person, or one of them is going to be a Catholic, or it doesn't happen that. The politicians who appoint the judges keep those matters into consideration. But don't be too worried about judges, getting judges who are old. To get to a position in the High Court, generally speaking, you have had to serve for many years on a high state or federal court. And therefore, in the nature of things, you are generally not going to get there until you are in your late 60s or 70s. I was appointed to the High Court in 1996 when I was 46, and therefore I had 13, 14 years to serve. So generally, people you don't have to worry about looking after people who are old, but the judges of the High Court are not necessarily going to have a lot of experience with the problems of the aged. They'll have experience with their own lives, and their own lives will include the ailments and conditions, but they're not going to include such questions of homelessness or lovelessness or all the other problems that we see with older people in our society today. So it's not easy, but I don't think that having a differential criterion is going to help. I think it has to be a basic time qualification, a basic experience in the courts before you are appointed to the High Court, and that itself is just going to ensure that they don't get there too late. And the fact that we are now getting many more women in the judiciary is a very good development that has happened in my lifetime. So the politicians are under pressure to respond to the popular will for the type of composition of the judiciary that should be adopted. And they tailor their appointments with that in mind, I think.
I'll sneak in one more online question and then we may have to wrap up. Do you find that Australia's constitutional amendment mechanism under Section 128 of the Constitution is too stringent?
Well, it certainly is very stringent, and there have been 45 proposals for the change of the Australian Constitution, and after a recount, I think it's 8 have been adopted. It's a very small number. It was copied in the 1890s from Switzerland. In Switzerland, they had a provision that you had to get a majority of the people nationwide in favour, but also a majority of people in the cantons, in other words, the states. And that's what we've got. It's got to be a double majority. It's got to be the majority of the people as a whole, but then reflecting the fact that we are a continental country of huge size with different communities on one side of this massive country to the other. There is this provision, you've got to carry it with a majority of the states. And that has been the difficulty, that getting the nationwide majority has sometimes happened, but they didn't get the majority in the smaller states. And the smaller states are part of Australia, and therefore they demand and expect that they will be given respect and opportunities to be reflected in the makeup of the law that is their constitution. These are not easy questions, but they're not all that difficult either in comparison to being a neurosurgeon and somebody who's cutting away at your brain and fixing up your neurological problems. I think being a judge and a justice of the High Court was relatively easy. In fact, my brother, David Kirby, was a judge of the Supreme Court of New South Wales. His life was different from mine because he was in charge of trials like Judge Marchon, the judge who is currently trying Donald Trump. And so David sits in when he was a judge of the Supreme Court, he sat in day after day after day of murder trials. Really difficult, very difficult cases, I think. In fact, I think more difficult than the cases I had, which had already been through 2 levels of very clever judges on the way. So I think the job of a judge is very difficult, but the people who are chosen on the whole are people who are not corrupted. When I got delegations from Indonesia or other countries, I would always say, the proudest thing I can say is, you see that phone over there? I've never had a telephone call from a minister saying, well, Your Honour, the government would appreciate this or that. Never. And I never got a brown paper envelope with a lot of cash in it. Never. So we've got things to be grateful for, and those things tend to be part of our inheritance from England. It's a tradition which has its weaknesses and tends to be conservative, but in the matter of integrity and independence, it's pretty good. And that certainly was my experience, and I believe it is to the protection of the people of Australia that is our case, and we must keep it that way. End of lecture, end of long talk. Big round of applause.
Thank you, the Honourable Michael Kirby, for your wisdom and inspiration tonight. Thank you for your judicial service up to the age of 17, and thank you for everything you continue to do after that age as well. For myself as a criminal lawyer, I've invoked your verbatim judgments in front of students on many occasions. That has ranged from your comments on the extended common purpose doctrine, chapter 3, right through to your attacks on the attempts to extend the provocation defence to include the homosexual advance defence. Your judicial work that you have done continues to appeal to the future, and your post-judicial work continues to be further inspiration for us as well. Thank you to your husband, Mr. Johan von Floten, for being here tonight, for driving you down here from Sydney safely today, and the inspiration that your relationship of more than half a century has actually provided to many of us. Coffee, tea and biscuits await outside for everyone else. Mr. Kirby, Mr. von Floten and also Professor Blake will be here till about 7:50 tonight if you'd like to have some further interactions with them tonight. And thank you all for this wonderful event and for participating tonight. Thanks.